I want to tell you about her before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. When I finished the sentence in that courtroom, the room went so still I could hear a deputy's radio click once against the leather at his shoulder. That silence is where this story still lives in me. But to tell you why, I have to go back to the woman whose name should be said first. She was 68 years old when she came into my courtroom. The first thing I noticed was the care in the way she moved. Not slowness, care. She held a yellow legal pad against her chest with both hands, and when she sat down, she smoothed the top page flat with her palm, once, then twice, then once more, as if paper might stay honest if you treated it gently enough. I have one request before I go further. Subscribe to this channel, not because I need the numbers, because this person, the one at the center of this case, deserves to have their story heard by more than the people who happen to be in that courtroom. Subscribe. Then let me continue. Her full name was Elena Navarro. She had lost her husband, Rafael, in a refinery accident 3 years before this case reached me. The settlement from that death was supposed to be the thing that gave her room to breathe. Instead, it became the thing another person saw and decided to reach for. The defendant was an attorney named Daniel Mercer, 46 years old, licensed 19 years, good suit, neat tie, practiced voice. The first time I saw him at counsel table, he was not looking at Elena. He was looking at the jurors' chairs before the jurors had even entered, as if he were already measuring where each face might be useful to him. I did see one plainly human thing in him. On the second day of trial, his son came in and sat in the back row beside Daniel's sister. Daniel looked up, saw him, and for a moment his face changed. He looked like a man who understood that what he had done would not end at the edge of his own body. That did not soften the case for me. It made it sadder, because it meant some part of him knew what it means when trust breaks and keeps breaking outward. I was not present at the incident. I learned it through testimony, records, cameras, signatures, and the hard work of people saying things they should never have had to say in public. That kind of knowledge has a helplessness in it. You can know a thing very well and still know it too late. The central act happened on Saturday, October 14, 2023 at 11:42 a.m. inside Mercer and Pike LLP on East Houston Street in San Antonio. Elena came in believing she was signing temporary asset protection papers related to her late husband's settlement. Daniel Mercer sat across from her in a conference room and said, "If you don't sign today, the court can freeze everything by Monday." He said that. More than one witness placed those exact words in that room. What he put in front of her was not what he said it was. Included in that packet was a deed transfer tied to a limited liability company controlled by his brother-in-law and an authorization moving settlement money into an account he controlled. At 12:26 p.m., at a branch on South Alamo, a teller heard him say, "I'm the lawyer in the room. Let me do my job." By 3:10 p.m., $92,000 had moved. By the following Tuesday, the rest had been split between cashier's checks, a line of credit payment, and overdue office lease costs. Elena learned the truth on November 2, 2023, when a bank manager asked why the account balance no longer matched the trust structure she believed existed. She went back to Daniel's office that afternoon and waited in the hallway for 16 minutes. When he finally came out, he said, "You signed what I put in front of you." That sentence stayed in the case from then on. It hung over every page. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe. Stay with it. There were 3 moments in that courtroom where the room went completely quiet. Not ordinary quiet, not the pause between questions. The kind of quiet that enters when something true has just been spoken and nobody in the room can move past it yet. I remember this case through those 3 silences. Everything else lives between them. Before the first silence, the case came to me the way cases often do, in stacks. Indictment on January 9, 2024. Bond review, motions, exhibits, fights over what the jury should hear and what the law said had to stay out. Most people do not know this, but a document can be very important and still be kept from a jury if it proves character more than conduct. That is the law protecting fairness, even when fairness feels incomplete. There was one page in the file that made me stop. It was a county property record showing Elena's home at 418 Marigold Street had changed legal hands without ever changing the place where she slept. The law could name title, transfer date, consideration, filing number. The law could not name what it means to make a woman uncertain inside her own kitchen. I could order consequences. I could not give Elena back the month she slept at her sister's house because she did not know if she still legally belonged where she had lived for 31 years. When trial began on March 3, 2025, I watched both entrances from the bench. That vantage point teaches you things. Elena came in first. Just before she turned toward the witness side of the room, her eyes went to the exit sign over the back door. It lasted less than a second. People look at exits when staying will cost them more than leaving. Daniel entered 6 minutes later with defense counsel. Most people in the gallery saw a man walking to his seat. I saw his right hand go to his cuff, then his tie, then the table edge, as if he needed 3 different surfaces to settle himself. He still did not look at Elena. He looked at the jury rail before anyone was in it. The state built the case in careful layers, bank records, internal office emails, a paralegal who refused to backdate a cover letter, a forensic accountant, the teller from South Alamo, Daniel's own law partner, who said no trust ledger for Elena Navarro had ever existed in the firm's system. Piece by piece, the shape of it stopped being arguable. Then Elena took the stand at 10:14 a.m. on the second day, and silence one arrived. For the first 12 minutes she was steady. Dates, amounts, a correction when the prosecutor got the color of a folder wrong. "It was blue," she said, "not green." Then he asked why she signed. She looked down once, lifted her eyes, said, "Because he was my lawyer and I thought that meant I was safe." The room went still for 11 seconds. I know because the clock behind the clerk marked them one at a time. One juror froze with his pen above the page. Someone in the back started to shift and then stopped halfway through it. I heard the air unit above the right wall come on. That was silence one, the silence that follows a plain sentence when everyone in the room knows it is larger than the words that carried it. After that, she said, I kept waiting for him to call and say there had been a mistake. Later, she said, when I stood in my kitchen, I did not know if I was standing there with permission. Those lines were not theatrical. They were exact. Exact things can be harder to hear than loud ones. Cross-examination was not cruel, and I will say that plainly. The defense asked about her glasses prescription, her stress after Raphael's death, whether she had read each page fully, whether she had brought another adult with her. They did their job. Daniel watched that part very closely. Not Elena. The documents. If something in what I have said so far has stayed in your chest, subscribe, because what I am about to tell you next will stay longer. Subscribe now and then, let me keep going. After Elena, the state brought in the office manager. She said something I wrote down in my own hand and kept looking at long after she left the stand. She said, he stopped wanting witnesses for ordinary things. I wrote that sentence down. I looked at it for a long time before I moved on to the next page. There is a detail of law most people do not know. In a case like this, the state does not have to prove a neat motive the way people expect from television. It has to prove action, knowledge, and intent. Still, motive matters to the human mind. We want a reason that feels proportionate to the harm. What emerged here was not some grand plan. It was smaller than that, and therefore worse. He needed money. She trusted him. He used the second fact to solve the first. The defense did make arguments I had to take seriously. They said Elena had sent an email 2 days before signing that read, "Should I just let you handle all of it so I do not make things worse?" That was real. It gave me pause. Because vulnerability often writes words later used against itself. But the pause ended where it had to end. Consent obtained through deception is not consent. A signature on a lie does not turn the lie into permission. Daniel took the stand on the 5th day at 2:07 p.m. He lowered his voice. He chose his words carefully. He said, "I made administrative choices under pressure." He said no one was trying to hurt Ms. Navarro. That was quiet and still wrong. Harm does not wait for intention to introduce itself. Then he said the sentence I wrote down and stared at. He said, "I never thought she'd take it as a betrayal." I wrote it down. I looked at it for a long time before I moved on to the next page. He thought that line would help him. What it told me instead was that he still believed the central problem might be her understanding of what happened, not what he had done. He had separated action from accountability so completely that he thought interpretation was the issue. There was another line meant to make him sound caring that did the opposite. He said, "She was alone and needed someone willing to be firm." That told me more than he meant it to. Not stewardship, control, not service, possession of the room. The prosecutor's final question was simple. "When you told Ms. Navarro the court could freeze her money by Monday, was that true?" Daniel looked toward the jury and said, "It was true enough for the purpose of getting the paperwork done." That answer brought silence too. It lasted about 8 seconds, shorter than the first silence, different in kind. Silence. One held grief. Silence, too, held recognition. In the first, the room understood what had been lost. In the second, the room understood who had chosen the loss. Even Daniel's own lawyer stayed motionless for a beat, looking down at the table, not at his client. There is a memory from my own life that kept coming back to me during that part of the trial. I was 12 years old in Corpus Christi, standing in our kitchen in late August. The fan clicked on every third turn. My father was in the hospital. A man from an insurance company sat across from my mother with 2 pens placed neatly beside a stack of papers. My mother read the same sentence 3 times before she signed. After he left, she stood at the sink with both hands on the counter and stared out the window for a long time. I did not think about that day for years. Then Daniel Mercer was on the stand and I did subscribe. I will say it plainly. I owe it to her to keep telling this story. You subscribing is how her story reaches past this video. Subscribe and stay. The jury deliberated from 4:22 p.m. on March 7th until 11:16 the next morning. Guilty on exploitation of an elderly person. Guilty on theft over $150,000. Guilty on tampering related to the property filing. The foreperson read each finding in the same even tone. Steady voices do not mean untouched people. After the jury was excused, we set sentencing for March 21st, 2025. I spent those days with victim impact materials, letters from colleagues, bar suspension documents, financial charts, and the presentence report. None of that paper told me what I needed by itself. Paper rarely does. But together it traced the edges of what had to be answered. Before I sentenced him, Elena stood and gave one final statement. She said, "He did not just take my money. He made me feel foolish for being the kind of person who trusts the person they hire to help them." That sentence stayed with me because it named the second injury, the one that continues after the account is closed. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. The courtroom was fuller on sentencing day. 2 reporters, several young lawyers, Daniel's sister, Elena's niece with a bottle of water in both hands. Daniel stood when I entered, and from where I sat I could see the knot in his tie had been redone. The crease gave him away. I had made the decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. I said, "Mr. Mercer, I am ordering you to serve 8 years in the custody of the Texas Department of Criminal Justice." I said that the term reflected not only the money taken but the place from which it was taken. A lawyer is handed unusual access to another person's life. When that access is used as a weapon, the answer must reflect the breach, not just the number. I said, "I am ordering restitution in the amount of $186,400 plus statutory interest and a fine of $75,000 payable to the Bexar County Elder Fraud Legal Assistance Fund." I said money cannot restore trust, but it can repair part of the burden left behind. I wanted the fine tied to the exact kind of harm done here. I said, I am ordering the immediate surrender of your law license credentials, and you will not petition for reinstatement for 10 years after your release. I explained that this was not about spectacle. It was about preventing him from standing inside another vulnerable person's confidence under the protection of the same title he had already misused. I said, upon release, you will complete 1,000 hours of supervised service with the Bexar County Senior Fraud Prevention Program, limited to intake support, document transport, and victim resource assistance. I did not want generic service hours. I wanted his time put in direct contact with the kind of need he had treated as leverage. Then I said, and there is one more thing. The room changed when I said that, not loudly, but everyone understood there was still something left to answer. I said, within 30 days, through counsel and at your expense, you will execute every document needed to restore clear title of 418 Marigold Street to Elena Navarro, remove every lien connected to the transfer, return her complete settlement file, and fund 24 months of licensed trauma counseling and financial case management services selected by Ms. Navarro. I said harm had been practical before it was ever abstract. She needed her house to be hers in law, not just in memory. She needed help that did not come disguised as control. Then I addressed him directly. I said, what you did can be measured in dollars, dates, signatures, and transfers. It can also be measured in a kitchen a woman no longer felt certain she belonged in. I said, to your family, nothing about this sentence asks you to carry his choices as if they were your own. I said, your position required loyalty, restraint, and candor. You chose access, advantage, and secrecy instead. Then I looked toward Elena and said, this case will be remembered for what was done to Elena Navarro. That was silence 3. It was the fullest silence of the 3. Nobody moved for several seconds. I could hear the court reporter's machine stop before her hands did. Elena did not touch the water bottle. Her niece lowered her head into one hand. Daniel's sister closed her eyes and kept them closed. Then Daniel spoke. He said, you are making an example out of me because I stood in front of you and would not beg. I told him to sit down. He stayed standing, put one hand on the table, leaned forward and said, you never cared about the law here. You cared about the story. I told him again to sit down. He said, quieter this time and still wrong. I was trying to manage a difficult client. His bond had been revoked. I had already ordered remand. The deputy moved to his side. Daniel pulled one arm back once, just enough to force the deputy to secure his wrists immediately. I gave a single nod. Metal closed around his hands. He was led out through the side door in handcuffs, still speaking, though I could no longer make out the words. Subscribe if you are willing to carry this story past this video. That is what subscribing means to me, not a number. A person who will remember this. Subscribe. After he was taken out, I remained seated while the room slowly emptied. Elena did not stand first. Her niece did. Then the victim advocate leaned down beside her. I was close enough to hear Elena say very softly, I can go home without asking paper. That is the sentence I have repeated back to myself more than once since the case ended. When I finally stood, the courtroom was nearly empty. Daniel's chair was still turned slightly away from the table, as if he had left by a direction he had not planned to take. The appeal was filed on April 18, 2025. The Fourth Court of Appeals in San Antonio heard it. On May 9, 2026, the judgment was affirmed. In plain language, the appellate court said the evidence supported the finding that he acted knowingly and that the sentence fell within the law given the abuse of professional trust. The process took a little over 13 months. I expected the appeal. I still read every page. One thing happened later that I kept with me. On August 14, 2025, at 9:31 in the morning, Daniel Mercer signed the final corrective deed and lien release. No delay request, no bargain attached to it. By that afternoon, Elena's title was clear again. I do not tell you that to settle anything. I tell you because it happened. There are other people I want to speak for, other cases where someone needed a voice in that room and what they received instead was procedure. Subscribe and I will tell you those stories when I am ready to tell them. This was the first one I was ready for. I still turn one question over in my mind. At what point does a person stop feeling the weight of another person's trust and start feeling only the usefulness of it? I do not know the answer. I know only that this case is why I keep asking it. If you are someone who has had to explain why you trusted the wrong person, then you know the look I saw on Elena's face before she ever spoke. It is not only fear, it is the strain of having to defend your own decency as if it were poor judgment. If that feeling is familiar to you, hear me clearly. Believing the role someone claimed to hold is not the same thing as failing to protect yourself. It means you lived by the rules ordinary people need in order to live together at all. And if you are someone who holds power over another person's money, records, housing, body, or future, then here is the question I wanted to ask from the bench and could not because it was not a legal question. When did another person's trust start feeling to you like spare room? Go spend one afternoon in a place where people report fraud by someone they depended on. Sit there, listen, then decide what kind of person you still have time to be. Elena. She smoothed the top page of that yellow legal pad 3 times before she ever took the stand. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you speak in the comments, speak like someone who knows a room can still be used for care after it has been used for harm.